Hi, my name is Stephen McMahon, and this is a short video to teach you why the case of Clarke against Nationwide News is an important case for an intermediary's liability. Firstly, we will look at the law. Pursuant to Section 18C of the Racial Discrimination Act 1975, it is unlawful for a person to do any act otherwise than in private, if that act is reasonably likely to offend, insult, humiliate, or intimidate another person or group. And this act is done because of race, colour, or national or ethnic origin. The case of Clarke against Nationwide News will show us that an intermediary will be held liable for any published content that breaches the Racial Discrimination Act, regardless of whether they are the original author or not. The applicant in this case is an Aboriginal Australian and a mother of 3 deceased boys who died in a car accident. She alleges that the respondent, through its online interactive discussion board, published material that breached Section 18C of the Racial Discrimination Act. The premise of the applicant's argument was that the published comments contained imputations that the applicant, as an Aboriginal, was an irresponsible person who failed as a parent and a mother. Despite not being the authors, the court held that it was the act of publishing that does the damage, and it is this that the law is trying to prevent. The test is an objective one, and the court held the comments were reasonably likely to offend if a reasonable person of another group would have been affected in that way if directed at them. In this case, the judge considered the perspective of adult members of the Aboriginal community. Whilst necessarily broad, it was not so narrow that it considered the subjectively emotional concerns of a grieving parent. With regards to causation, the judge held that it is not open for the respondent to say, "But we only published what the reader sent us." The judge stated that the act of publishing an offensive comment of someone else is just as offensive as if the original author had done so. Notably, the respondent already moderated all comments. This, his Honour stated, could raise a question of exemplary damages, but subsequently deemed inappropriate. Let's have a look at the comments in question. If these young people had not been killed in the course of their criminal activities, they would have continued stealing cars and putting the lives of innocent law-abiding citizens at serious risk. Will the law-abiding public be given important information re the criminal history of these families? The judge held that this comment went beyond the rational discussion of the incidences of juvenile crime and Aboriginal communities. The inference that the families have criminal histories, which explains how the boys learnt to steal, was held to be an accusation without proper foundation and is plainly offensive. Now we'll look at a similar comment that was held not to be offensive. I suggest to the Sunday Times reporters that they look at the criminal history of these boys. They were certainly not little goody-goody two-shoes. Talk to the local police, they knew all about them. The judge held that this comment was not a breach of Section 18C of the Racial Discrimination Act. This comment is distinguished from the previous comment as it is not as far-reaching, and it did not cast blame over all Aboriginal peoples. This meant that it did not fill the reasonable person test as required by the Act. Ultimately, 3 other comments were held to be in breach, and the applicant was awarded $15,600 in compensation. This is an important lesson to all online media companies with interests in Australia, that even if they are not the ones writing the material themselves, as publishers and moderators of their content, they will be held liable for any breaches of the Racial Discrimination Act. Thank you.